Nani ninjani molweni afsheni twabelanda. Guys, today we have a Department of Private Law where we talk about the law of damages. And we have an assignment, LPL4802, which is a written assignment, which is assignment number 1, which is due on the 16th August 2024, which has a 25 marks. And then we have a question number 1, which states clearly that critically discuss the decision. Remember, you are discussing. You are not summarizing. You are discussing the decision of Mtlekeza v. Gali with specific reference to defamation and the claim for damages in that respect. Do not include a discussion of the Prescription Act. Your discussion should include but not limited to what constitutes defamation and how the court dealt with this in casu, the two-stage inquiry, mitigating and aggravating factors. You should include your personal view of the decision in casu and provide reasons for your view. So you should include your personal view on the decision. Since you are going to discuss it, then you include your view of the decision. Whether you stand with the decision, if you stand with the decision, you provide your own reasons. If you don't stand with the decision, then you provide your own reasons. But the best thing is that this is a discussion, right? Please note that the law of damage may not in full. The full video is on our exclusive videos. Press join on our channel and pay 100 Rand to watch the full video and other exclusive videos. So you'll be able to watch all your module videos. We'll be keep on uploading them on the exclusives. Since that assignment is talking about defamation, it's very much important that we start to look on the defamation. Our focus now shifts to defamation. Defamation consists of the impairment of the plaintiff's good name and or reputation in the community as a result of the defendant's action. The reasonable person test is applied to determine defamation. Remember, you must have information about defamation before you answer the question. Read Lee Rocks v. Day to establish if a separate action for iniuria could be applied where a single action by the defendant causes more than one form of personality infringement. The use of the reasonable person test, objective test, in determining defamation provides for the basic theoretical foundation for the existence of loss suffered by juristic persons. Infringement of dignity lies with the subjective feelings of dignity or self-worth of the plaintiff. The plaintiff must prove that he actually felt insulted by the actions of the defendant. The extent of the impairment of feelings is concomitant with someone standing in life. Infringement of the right to feelings consists in different forms of iniuria other than that connected to dignity. Now we have read about defamation. We know what is defamation. Before we continue, you must know that you may request any document used in this video if you have paid a fee of 100 Rand or you are doing classes with us. So this is two options. Another step is that don't forget that section 10 states very clear that everyone has inherent dignity and the right to have their dignity respected and protected. When we talk about the human dignity, you must not forget the words of the Justice Oregon in Dalwong Shalambi Thomas vs. Minister, who said, "Human dignity therefore informs constitutional adjudication and interpretation at a range of levels. It is a value that informs the interpretation of many possible or other rights. This court has already acknowledged the importance of the constitutional of dignity in interpretation, rights such as right to equality, the right not to be punished in cruel. Human dignity is also constitutional value that is a central significance in the limitation analysis. Section 10, however, make it plain that the dignity is not only foundation, then it's a sum of the scenario that talks about the human dignity if you want to read much about the human dignity. Then they even give by the journals where they talk about the respect, saying that respect for the intrinsic worth of every person should mean that individuals are not to be perceived or treated merely as instrument or object of the will of others. Dignity on this account sets the full floor below which ethical and legal behavior may not fall. And then we come to the real stuff now. The real stuff is that this claim is based on Actio iniuriarum. So defamation is based on when you want to claim the defamation, you have to raise the Actio iniuriarum. The interests of the personality protected by the Actio iniuriarum are those interests which every man has as a matter of natural right in the possession of unimpaired personal dignity and reputation. Therefore, to succeed with his Actio iniuriarum, the plaintiff must show that the act complained of constitutes an impairment of his person, his dignity, or his reputation. In my view, putting a man next to a toilet pot full of human feces is a violation of his constitutional right as enshrined in Section 39. Then they are talking about the claim of the iniuriarum, which is used for defamation. I'm giving these all things as so that you can able to remember what the assignment was said. In the assignment, they said that you must include your personal view. So I'm giving as much as cases so that you only know how to make your personal view so that you understand when we go forward, we started to answer the question, right? So now we know about the human dignity and we know about the purpose of the uranium is not much to obtain compensation to harm done, as it established some right contained in, for instance, the Constitution, the protection of dignity and reputation. In such a case, if the plaintiff successfully establishes right, he is entitled to nominal damages, although he proves no loss. To succeed with his claim, the plaintiff does not have to prove any loss or damnum. The leading case now is that one of Edwards. Then there was some form of they said that, however, many cases were through in form of the action is one for damage. It is really both for substantiate, and then they said something that you may read, and then okay. Now let's talk about this book of ethylene, which many of you use it. They say in the delict page 223, theoretically a non-patrimonial loss, unlike patrimonial loss, determined by means of comparative method. Now this is very, very important. This is very important. Now this one shows that it's a theoretical and non-patrimonial loss, unlike patrimonial loss, determined by means of comparative method. Then you know now that the damage is determined by what? By comparative method. Therefore, the comparative method used in the patrimonial loss to determine the damages is a necessary comparative method used in the determination of the damages in a non-patrimonial lawsuit. A comparative test may be defined as follows. According to the sum formula doctrine, damage consists in the negative difference between the relevant person's current patrimonial position, and then there was a test that was formulated, and then they give even example by the case of a Transnet Limited v. Chaba, where they talk about now it's now beyond question that damage in delicts are assessed according to the comparative method, especially that method, in my view, determines the differences or literally the interest. The award of delictual damages seeks to compensate for the difference between the actual position that obtains as a result of the delict and the hypothetical position that would have obtained had there been no delict. I know that you do not know, you may remember, or you are doing damage for the first time and you do not know this case of a Transnet limit. This is an important case. Let me prove that it's an important case. Let me show you. Sorry. This is the Department of Law. This is a damage law. As you can see, it was asked in the first semester, and then this is assignment number 1, right, in the first semester, and the due date was 28 March 2024. Now I'm going to show you the things that I'm talking about. Now you should check. They said that in the Transnet v. Lisichawa photo scan, the case that I'm talking now, the court expressed the view that it is now beyond question that damages in delicts are assessed according to the comparative method. Write an essay where you discuss the validity or relevance of this statement with regard to the assessment of damages in the South African law of damages jurisprudence. So the only way, the reason why I started back to give you some information is because I want you to understand about non-patrimonial laws and how they assess their damage. So now you know about this case, and how they assess their damage is here in this case. Then they talk about how they assess the damage. They said, to simplify the formula, the comparative method of determining the damage, one must first to determine the damage after the delict has been committed. Secondly, to determine the hypothetical position had the delict not occurred. Step number last. Then they subtract those 2 steps, and the difference is the amount of damage to be awarded. Now we know how they awarded the damage according to this case of Transnet v. Sichava. Right now, I have given you some background that we must use so that you can able to prove the point of view. So now we have read everything about it. Now it's time for us to go straight to answer the question. Now we are here with the case of Mdlelekazi vs. Kelly, the case that we have been, they have given us a task to discuss it. Okay, I know that you'll go and read this case on your own, and then you know, and then you must know that they said that University of Cape Town published an article where there was an applicant who was profiled with respect for for being the first black actuarial science student. And then when they published it, unfortunately, the lady saw it and published on the Twitter that she got sexually assaulted by the same guy, and then she provided some reasons. And then if you read this case, they said that she even consulted even some lawyer, a friend who was a lawyer, who told her about the consequences of the things that she was doing. And then she continued to say that she was sexually assaulted, which was the defamation. Then the applicant came to the court for filing the defamation. And then you can read this one. They made it clear that we must not talk about the prescriptions. These are the prescriptions, section 11 of the prescriptions. They made it clear that we should avoid talking about prescriptions. So we'll just script this, the prescriptions. So we'll start with the defamation claim. Since those all are prescriptions, we'll start with the defamation claims. So we want to know how the quantum of the damages are allocated. We have came much about the quantum of the damages, right? How they are how they are portioned. Remember, the person is a number 1 student and is a lecturer in the University of Cape Town. This person is a lecturer in the University of Cape Town, and now there's an allegation of sexual assault. You know what happened when there's allegation of sexual assault. So, but here we are much into the quantum, which will be damages. We are on the quantum of the damages, how they were allocated. The first one was to question whether how the statement should be defamatory. Then the court firstly assess whether how the statement should be defamatory. Then they give a reason which you must start to summarize about the defamatory. They said it must be caused probable impairment to the claimant's reputation in determining whether or not publication is defamatory. and therefore prima facie wrongful. The court is required to undertake a two-stage inquiry. First, the court has to determine the meaning of the publication. In so doing, an objective test is applied, and we have already told you that defamation is based on the objective test. Okay, when we were talking about the definition the definition of defamation is applied, and the question is posed that would a reasonable person of ordinary intelligence understand by the publication. This would include what a reasonable person may imply from the publication. Secondly, the court has to determine whether or not the meaning is defamatory. In this regard, consideration is given the manner. So when we discuss in this case, firstly we discuss what this case was about. Then this case was more of a wanting to explain why the statement is, how the statement is a defamatory. The statement is defamatory if it meets the objective test, where a reasonable person making such a statement will be seen as the person who implying something which is negative about the person. Then that will be a statement which is considered defamatory. Then they will go to the second way, where they will determine the meaning and the content of that statement, whether the meaning of that statement is a defamatory. So that's another how they allocate the damage. So now we know number one, we know. Then they gave example on the 17 about the applicant. Before we continue, I would like to refer us to another case of defamation, which is very important because it's a similar case of a sexual assault which happened in UCT. So in this case, the judge has granted the payment sum of 80,000 in respect of the harm caused by the plaintiff's reputation, payment of the 23,279 in respect of the past expenses, and payment of sum of 200,000 in respect of the future medical expenses. So let me give you some overview of what happened in this case. The only reason why I'm doing this, I want you to have knowledge so that you can check the mitigation and whether the money that was granted in this case is just, and what about this case, because they are similar. So it's very much to compare the cases so that you have a nice discussion. So in this case, there was a killing. You know, the person was killed. The student that was called Missy Uyinene Mtwechana. I know that you know this lady who was killed, and then there was a public outcry in University of Cape Town after being killed. So after being killed on the 4th September 2019, the university held a highly publicized memorial service for the slain student, Uyinene. Then hundreds attended the service. At that service, a list of alleged rapists at UCT was read out that included the plaintiff, who was identified as an assaulter and a rapist. In addition to that reading out, the list was disseminated to attendees at the memorial service and made its way into social media platforms. The list has since been circulated on the anniversary of the tragic event. So now, because the plaintiff the name was read out as the assaulter and the rapist, now he has to ensure that he's somewhere safe, because he was not safe at all around those students. And then he instituted a defamation of a character against the person who posted, the person who included her on the list. But we'll deal with this one on the part 2 when we are going forward with the case, with the case of when we are going forward with this case. The things that I want you, when we go forward on the next video, will be checking the damages, to check whether the damages that was apportioned here is just, since here the damages that were apportioned were It's like a 60, or when I was reading it was like a 60. Yes, the applicant was here on the assault to pay 65,000 within 60 days or after this order. But it was 60,000. But remember that case that we're reading, the person has paid like a 300,000 for including the applicant as the assaulter and the rapist. So we are going to check whether on that case of a defamation, because the same case, that one is dealing with a sexual assaulter and a rapist. This one is dealing with a sexual assault, which is one thing. So we are going to check on the damages of this case and the damages of that case, so that you have a personal view on this one case that you are discussing. It's very much important. Then on the part 2, I'll be showing you everything so that you know how to answer this question. Lastly, please note that the law of damage may not in full. The full video is on our exclusive videos. Press join on my channel and pay 100 Rand to watch the full video and other exclusive videos. You may request any document used in this video if you have paid a fee of 100 Rand or you are doing classes with us. The full video will be uploaded before Sunday, 4 August 2024 on our exclusive video of 100 fee. Remember, 100 fee allows you to watch all our videos, our exclusive videos. So it's very much important to subscribe or to join our fees so that you are able to watch all the videos. So we'll be talking more about damage on that exclusive video and how to answer this question. Have a nice day, guys. We'll meet on our exclusive. Good night.